Good evening. Captain Retired Matt Edwards here with the next installment of the Facebook Live weekly report for the observation post, as I call my group. And my voice sounds a little strange to me. I had a tooth break off again recently, Monday, right after I had a cleaning and dentist. I think it's a coincidence, not blaming them. But big hunk of a crown fell off and feels strange, my voice does to me. Anyway, I'm going to try to wing it through a little bit late, but I don't want to be on here all day anyway. I'm going to go through 3 points of my numbered list, and then I'm going to wing it on a few points, a few ideas I had. Number 487 in my numbered list, I might do a column. I put a column, question mark, unfair deductions 2, attack Canada Pension Plan Disability and Canadian Forces Superannuation Act clawbacks in SISIP / Veterans Affairs Canada. Now, before I came down here, I didn't know what the next 3 items were going to be. Might seem like bad planning, but it's just how I do things to try to keep my sanity. But that was one of the things I was going to talk about anyway, so it's coincidental, fortuitous, good. Now, I've said this many times. The government is supposed to protect pensions. So it puts in place things like Canada Pension Plan Act, Section 65(1), and the Canadian Forces Superannuation Act, Section 83. And those are supposed to protect the pension from creditors. Now, it just so happens that the government becomes a creditor many times, but it doesn't go to court and get a judgment like it's supposed to, which is one of my key theories. If you owe someone money, you can't just collect it. You're supposed to go to court, prove it. After you prove it, then you're supposed to be able to collect it because you've been sanctioned by the courts. But the government and insurance companies are not following the debt collection rules. So they're just collecting it by withholding their own payment. They're not taking the payment that you're getting. Like when the Pension Act pension was being clawed back from SISIP, it wasn't a diversion of the Pension Act pension. It was they were merely getting the information that they had no right to and then taking money off of the long-term disability insurance that they were supposed to get. Now, because I want to get out of here fairly quick tonight, Number 488, bridging and survivors. That one's going to be fairly simple because I don't know what I was talking about back then. However, survivors, a lot of pensions have a survivor clause. Now, the government would have you think that it's always 50% of the pension, what the pensioner was getting. But that's not true. Certain pensions, you pay a little bit more for it, you contribute more for it. And then, when you die, your spouse, your widow, gets 100% of what you were getting. But that doesn't fit well with the government's agenda. They're gaslighting. So they don't mention that it's up to the pension administrator and the people that are contributing, like, they're the ones who support the pension. And they just make everybody believe that this is the way it always is. Number 489, Spinks Federal Court appeal case, I think it was 1996, and the Canadian Forces Superannuation Act and Canada Pension Plan implications. Experts on pensions have a fiduciary duty to inform the contributor because they're not experts on pensions, which are highly complex. I consider myself a self-taught expert on pensions. I think I'm one of the most, foremost experts on pensions, especially federal superannuation act pensions in Canada. Until someone comes along and shows what I've been saying to be false, I'm going to wear what I consider to be the crown. Now, this is also coming up recently, in my head at least, when I see things like there was a lady. I found this in the Hansard recently, and I posted some pictures of it. Mrs. Sinclair. She lived in Saskatchewan. Her story was repeated in the Hansard when her member of parliament told her story about the fact that she didn't get a Canada Pension Plan disability pension even though she became disabled. She contributed to it for 13 years between 1966 and 1978. She became disabled. She never contributed to it after. She never heard about the Canada Pension Plan disability until many years later, and then when she heard about it, she was outside the timeline, they said. Bullshit. Pensions are fiduciary in nature. Somehow, everybody thinks that if you don't apply in time, you are not entitled to get your property back. The lady paid her money into the pension plan for 13 years, and that gave her an entitlement to get her property back. Just because she didn't apply, and by the way, I have to admit a mistake. For many, many years, I've been saying that the Canada Pension Plan disability had a vesting period of 2 out of 3 years. In other words, you had a grace period of 1 year between 1966 and 1998. In the Hansard, I recently found that that wasn't true. That the vesting period, as I call it, or the period that you needed to qualify for the Canada Pension Plan disability, was actually 5 out of 10 years. So you had to have 5 years of contributions out of 10, and that's a pretty loose definition. A lot of people could qualify. Even this lady I was talking about, Miss Sinclair, she would have qualified if she had applied in the 60 months, 5 years, after she last contributed. Now, then in 1987, they changed the contribution period to 2 out of 3 years. Now, I can tell you that the long-term disability insurance companies would not like that to still be in place. And I wonder if it's why it changed only 11 years later. Because pensions are supposed to be long-term, and they're not supposed to change much. So you had a rule at 5 out of 10 years to qualify, which makes me think of the Disablement Canadian Forces Superannuation Act pension, where you need 10 years. And then they changed it to 2 out of 3, and then in 1998 they changed it to 4 out of 6. Now, make up your mind. Why should we take them seriously when they changed the thing 3 times, twice within 11 years? So, I think they might have my expert opinion again. People can deride me, ridicule me for claiming to be an expert. But I'm wondering if it's meant to allow long-term disability plans to get people to apply for Canada Pension Plan disability, because if they're like the Service Income Support Insurance Plan, Policy 901-102, the first 24 months on the insurance plan are considered to be own occupation, or 3B definition of disabled. Now, the Canada Pension Plan disability is a 3A pension plan, so you can't very well ask a person who's disabled to the 3B category to apply for a 3A pension, can you? Within that 2 years while you're on the 3B definition. Now, by the way, that's a fairly recent development. Up until 1999, until I find something like that Canada Pension Plan that shows me I'm wrong, I think that from 1969 to 1999, the SISIP policy used the 3A only definition, and in 1999 they changed it to a 3B for 2 years, and then 3A up to age 65. Now, that would increase their costs a lot. Not as much as you would think, because they made it automatic after 1999 for anybody medically released, which is common sense. If you're disabled to do your trade, then you had to get your long-term disability insurance. Now they made it say only got it for 2 years, because normally, don't ask me where I got this from, but I have done a lot of research over the years. About 16%, so round it up and say 20%, So about 20% of the people who go on it in any particular year as 3B will then be on it past 2 years to age 65. So the cost would go up, but not as much as you would think, because everybody said they had 1,000 people that went on in year one. At the end of the 2 years, 800 of them would be kicked to the curb, and 200 of them would continue to age 65. Anyway, now, another thing now, I'm going to get out of that topic and go on another one. I'm going to read out, I'm not just trying to toot my own horn or anything, but I wrote a column and I posted it today. And I'm trying to get people to understand what I'm working on. And I'm working on a lot of stuff. But sometimes I come up with what I call a plan B, or a backup plan. Because they might, through corruption in the government or corruption in the courts, somehow win something. But I don't think they can win it all. So anyway, Plan B or backup plans. An observation post column by Captain Retired Matthew Edwards, CD, BPE, BED, Canadian Declaration, Bachelor of Physical Education, Bachelor of Education. Many of the things that need to be fixed in how Canada treats the disabled person, including many disabled veterans, in-service veterans, can have a backup plan, which would help the disabled citizen even if the ultimate goal was not achieved. Here are some examples. Number one, while having the Canada Pension Plan Disability, or CPPD, clawbacks, which are in brackets, I'm trying to educate people, teach people a bit. They are also called offsets or set-offs. Stop entirely is the ultimate goal. A backup plan is to have the flat rate that was increased by 300% in 1987 and as a clawback. The reason why this amount cannot be taken into account is to save other people money is A, public policy dictates that this money is meant to assist a disabled person, not anyone else. B, while the economic portion of the Canada Pension Plan Disability might be linked to the clawback, in theory, the statutory flat rate is not linked at all to income. It might be viewed as a form of charity, which is not set off in tort damages, for example. Number two, multiple flat rate clawbacks have to end. This is essentially a backup plan for the first backup plan. In the case of disabled and service veterans getting Canada Pension Plan Disability, the Crown claws back the flat rate more than once. A, the Canadian Forces Superannuation Act Retirement Private Pension claws back Canada Pension Plan Disability under Section 15.2b. B, the Department of National Defence, or DND's Service Income Support Insurance Plan, or SISIP, Policy 901-102, takes that flat rate into account in Section 24A and Section 44A of the policy. C, Income Replacement Benefits, IRB, reduces its own payment in accordance with the Veterans Wellbeing Act Regulation, Section 22. 3, multiple clawbacks must end. Canada Pension Plan Disability is clawed back from up to 3 other payments for a disabled and service veteran. See the previous point, but include all of the Canada Pension Plan Disability instead of just the flat rate. 4, taxing. SISIP and IRB. Under Income Tax Act, Section 6. Parliament said a payment must be periodic, so the payer must exclude any non-periodic payments or lump sums. While a lump sum is less common than periodic payments, this measure would make things legal, fairer, and save money on taxes for the disabled person getting a lump sum. 5. Canada Pension Plan Disability is the largest long-term disability in Canada, but it does not operate like the other plans for taxes. Under Income Tax Act Section 61F5, all career long-term disability pensions are deducted before taxes are charged against the remainder. The same should apply for Canada Pension Plan Disability. This would make the plan fair, as the same rules would apply and the disabled person would have to pay less money on taxes. Number 6. Right now, Canada has a SISIP policy, uses SISIP policy 901-102 as a form of workers' compensation, or WCB, for disabled veterans, but they fail to obey the practice of not issuing a T5007 tax information slip instead of what they file, which is a T4A slip. A disabled civilian gets a tax advantage because of this, as no taxes apply to this slip used for workers' compensation and welfare. Failing to use a T5007 costs the disabled veteran money that they could use just like the disabled civilian. Number 7. While I was on leave without pay, or LWOP, with the government, I bought back my time from my pension. That increased my pension, but my purchase did me no good, as Sun Life policy 12,500G clawback, this increased my pension first, did me no good, as they claw back the increased amount. Clearly, as a backup plan to having them stop the Public Service Superannuation Act under Section 1010, the increased pension amount has to be ruled as not available for clawback. While a small amount, this will be fairer than is what is happening at present. The purchase hurt my finances. Number 8. If SISIP policy 901-102 had to return the premiums paid, both parts, it would be a good backup plan. Now, I gotta give you an editorial comment here. I hesitated to put that in there because I think it'd be letting them off the hook if they only had to pay back the premiums and not give you the insurance that the premiums buy. Carrying on. This would be based on the remedies set forth in the Rapino QCCQ 2003 case, and then I put the quote right in there because it was only a short one. Paragraph 37. Condemns, this is the judge listing off what they ruled on, condemns the defendant, which was Maritime Life at the time, to reimburse the plaintiff for insurance premiums totaling $964.25. I mean, it's next to nothing, but it'd be a smack in the face for them, so I think I'm all for it. So now I'm trying to clue up again. Plan A is a priority, but having Plan B ought to be a good thing. However, the Crown ought never have done the things listed here. A common law democracy should have the government act fairly, reducing distrust in it when it acts selfishly. In fact, having to sue the Crown is a large burden. After all, the government is the sum of all the people in a nation, so it has an enormous advantage over any person or group. To recap the theme of this column, because I thought I was getting off track a bit, the Crown cannot continue to do the things that it is doing, and even if the solution is a partial one, the disabled victim of government oppression is better than nothing. That is not to say that the Crown should escape total transparency and accountability, of course. Now, let me link some of that stuff that I've been watching on YouTube to what I was just talking about. Accountability. Donald Trump in the U.S. wants to have complete immunity for anything the president does when he's the president. That's insane. If that's the case, then you might as well say we don't have the rule of law. Now, I saw another thing that I thought was nuts when they were talking about the Supreme Court and the states was hearing arguments about this. They were talking about official acts and not official acts and stuff. Why are they talking about that shit? The issue at hand is if the president commits a crime. Crimes have two factors. The first one is a mens rea, or guilty mind. So if you apply that to the president and he does something because he has a guilty mind, then how can you try to say that he should have immunity from any prosecution? Forget the actus rea. Like there was a lawyer that was bringing up something and being questioned by the Supreme Court judges, and he said something that I've been thinking about. He said the president had access to legal advice. So prior to taking an action, you get legal advice to see what the risk is. Now, I'll link that to my own case and my own meeting with Seamus O'Regan, my Member of Parliament. A few years ago, I went to an open house. I met with Seamus and I asked him to get a legal opinion on the clawbacks being legal. I asked him not to go to the DOJ because I think they have a very large conflict of interest because they help to write the laws and they're ignoring the laws. And Seamus said he wasn't sure he could do that. But he did say something that niggles me to this day. And he said that laws are open to interpretation. Now, it might be true in some fashion that laws are open to interpretation. But in the vast majority of cases, that is not true because laws have to be clear enough that people can obey them. They have to be spread by the people who make the law, and they have to be clear enough to be able to be understood. And my Member of Parliament, his job is to be a lawmaker. So if I had thought of it at the time, I should have said, Seamus, are you telling me that any law that you have voted on and that became a law is open to interpretation by me and other people? Are you trying to say that we shouldn't give any credence, we shouldn't pay any attention to the laws that you're talking about because they're open to interpretation? I could ask him, is the Income Tax Act open to interpretation? Can we disagree with things in the Income Tax Act? Like we could talk about, say, Section 6(1)(f) of the Income Tax Act, which requires a payment to be periodic in order to be taxable. But the government taxes it whether it's periodic or not periodic. So can we talk about interpreting the Income Tax Act? Now, I was thinking about that earlier, and I know I confuse people a lot with tax stuff sometimes. But CRA would have to do a better job explaining things to the public, including people who make payments, even though ignorance of the law is no excuse. So Income Tax Act Section 6(1)(f) states quite clearly that a payment must be periodic. So the people making a payment would have to look at that law and not include any other payment that was periodic. If there was a mixture of payments, say you were getting your long-term disability late, then you shouldn't have to pay any taxes on the money that was a lump sum, because whatever screwed it up is not your fault, and it really was technically, legally not periodic. Now, I got 2 points to make about that, on a similar note about it, actually. More than 2, probably, because once it gets going, watch out. Section 6(1)(f)(1) taxes income replacement benefit in almost the same manner as SISIP policy 901-102. However, SISIP gives you the career premium deduction under 6(1)(f)(5), and there's no such career premium deduction for income replacement benefit. That isn't fair. In addition, there's no periodic put in there, even though the two laws are so similar that they didn't put it in an entirely new section, but they inserted it just below SISIP, and they put a 0.1 on it. Just like people with software and stuff, like might be Windows 3.0, Windows 3.1, and stuff like that. So, in reality, income replacement benefit shouldn't be there at all. Now, that's my legal opinion, even though I'm not a lawyer, but I could say it's my tax opinion, because I used to work for CRA for 16 years. Section 6 of the Income Tax Act is about fringe benefits of employment. Now, the income replacement benefit is not a fringe benefit of employment. It's more like workers' compensation. Now, workers' compensation is listed in Section 110 of the Income Tax Act. You could also make the argument that it's akin to the Pension Act pension, which is listed as being exempt under Section 81(1)(d) of the Income Tax Act. So the government ought to have refrained from taxing the compensation paid to disabled veterans in much the same way as they do for disabled civilians under workers' compensation and under the Pension Act for the disabled veterans getting the Pension Act pension. Because, I mean, it's not like it's written in stone anywhere. The government did tax the Pension Act between 1933 and 1942. That's secondhand information. I did not find it from the Hansard, which is my prime source. I found it in the 2005 Veterans Affairs Canada reference paper. Now, you got to think about what happened in 1933, the Great Depression. So the government was clearly looking at for ways to save on taxes. So anything that is taxed, they only make a net payment. It's not like a normal employer. If you're a normal employer, you give your employee their net pay, the government gets the money, not the employer. But when the government's the source of the payment and they tax something, it's a different kettle of fish, as they say here in Newfoundland. So any time that they're going to look at this stuff, this is where the rule of law principle comes up, and about the government being bound by the law and the government looking at legal principles and doing the right thing. Because if enough people, and I'll give the example for the United States Supreme Court, they call it SCOTUS. Right now, public trust in SCOTUS is listed at 40% according to polls. Now, that's an institution that doesn't have any power over people except as persuasion. You don't want people thinking that their rulings don't matter. Because people are saying corruption in the courts, which happens in Canada too. In a 2003 Supreme Court of Canada case that involved thousands of disabled veterans who couldn't manage their own affairs, the Supreme Court of Canada gave the government a win when they should not have, and they ruled that you can expropriate property from people when you write legislation that clearly gives you the right to do it without compensating you. And you see, that's a variation, a divergence of the common law. Like if you wanted to build a property, if you own property and the city wanted to build a road, and they said that we're going to have to expropriate your property for the common good, for the good of the many, over the good of you, they had to pay compensation. Now, you might not agree with it, but it still has to be what's called fair market compensation. You can't expect to get paid an enormous sum, but they can't take it from you without giving you something. But the Supreme Court ruled in the Arthurson case that in 1991, the government wrote the Department of Veterans Affairs Act, Section 5.1, brackets 4. And they made clear law that said that they could expropriate the property of the veteran. But you know something? They must not think that we can read. That law is still on the books, and I can read it for myself, and so can you. Look it up. It states words to the effect, because I don't have it written in front of me. No interest shall be paid on any compensation after such and such a date in 1991. Did you hear me talk about the word expropriation? How can the Supreme Court of Canada say that it was clear language to expropriate property? They didn't say in Section 5.14, we are going to expropriate the interest, which is property, from the disabled veteran by not paying them any interest prior to 1991. We're not going to give them any of their property back. Nope, they didn't say that. $1.09 billion was the amount that was supposed to be paid to the veterans. But the Supreme Court of Canada said that that was too much money for the government to have to pay. The taxpayers should be let off the hook. So the people who became disabled serving Canada, and adding insult to injury, they couldn't manage their own affairs. So because they couldn't manage their own pension, Veterans Affairs Canada was looking after the bills for them. Some people might say, that's great. Look at how good the government is looking after all the bills and that for the person. They're taking on this duty for the veteran. That's wonderful. Well, the problem is when you're using somebody else's money, you got it in the bank, you had to pay them interest. That was why the government wrote that law, to deny the veterans the interest. And the Supreme Court of Canada said, listen, government, you go fuck yourself. You want to write a law to clearly state that you want to expropriate the property of the disabled veteran who was disabled in the service of his own country, and he cannot look after his own affairs anymore. Well, you go back and amend the Constitution, because Section 9213 of the Constitution Act says that property and civil rights are the purview of the provinces. Now, the Department of Veterans Affairs Act, Section 5.14, is a federal law and not a provincial law. So your law is unconstitutional, you dumb fucks. Oh no, Supreme Court of Canada overlooked the Constitution. Money over justice. Now, on that note, I'm going to say goodbye. See you next week.